Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian C.U.B.A. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian C.U.B.A.
Hi, everybody, and welcome to the June 2025 edition of the Third Fridays podcast. The year is halfway over. Summer weather is here, and I am joined by a gentleman dressed to the nines in a perfect lawyer costume. But before we get to him, I'm going to review last month's show. If you guys did not get a chance to listen to it, it was a really great discussion about artificial intelligence and its role in the current legal landscape as well as our own industry. We had one of my colleagues, Erica Fersch, talking about the presentation that she gave for lawyers and judges on New Jersey Law Day. She was asked by a judge to present on artificial intelligence, and we talked about how we are using it in our practice. Hint, hint, we are not. It's just not safe based on all the security issues and the privilege concerns we have. But it's a really great discussion about where it is and where it could be and how other people that are using it actually have some pitfalls and some worries dealing with their work product. But if we can pivot now to today's and this month's show, we have a guest here that's here for the very first time, which is always fun in the history of Third Fridays podcast. Really just reminds me of how old I am. But Bradley Haymes, attorney here at Lois Law Firm, welcome to the show. First time.
Hi, thank you for having me.
And we were talking about some of the wins that you've posted on your website. And when I reached out to you, Brad, I said, hey, I've enjoyed reading the last couple wins you've had. And I think the funniest thing about it was you actually reminded me of all the wins that you've posted on the website. And there were about 4 or 5 with 2 in waiting or something like that. Right. And so we kind of dug through the archives and I was like, oh man, no, that is a great win. And so we actually have so much to talk about that we might end up having, a very long podcast. But I think where our listeners can really learn and understand from how we got to these results are really about just the nature of what we deal with as defense attorneys. I think that oftentimes people look at us as, the bad guys. You represent the employers. You're fighting people who are injured and need these benefits. And I think your cases kind of just line up perfectly with why it's really not the case, right? And the first case really that just, I might remember it for the rest of my life, has to do with something called dragon's blood. So can you give us a little backstory before? We said they're about wins. So to everybody listening, it's all going to come out good for us. Right. But what is the backstory of how this accident happened? What was the claimant doing at the time or alleging he was doing, so on and so forth?
So in that one, the claimant was a recycling plant worker, and he was alleging that he stepped on a nail through his boot at the plant and ended up having an infection very shortly after that. His toe ended up getting amputated, his big toe. After that, he continued to have an infection, ended up losing his second toe and, a significant part of his foot. So pretty ghastly injury as far as he was claiming. But then when we looked into it further and subpoenaed his hospital initial records, he was telling his hospital that he popped a blister on his toe with a nail and that it became infected. And he also had uncontrolled diabetes and just a whole slew of comorbidities.
And it's one of those cases where it's very obvious that the person has a disability, needs treatment, a legitimate injury. It's not that common that we would basically concede all of those things, right? We're conceding that you have an injury, that you need treatment. It's just not related to our policy. It's not related to our work activity, right?
And he, in the situation like that where it's an amputation, obviously no really way of us getting an IME to say this didn't happen at work.
Right.
Really nothing, no evidence to go by at that point.
That's also a good point too. The idea that defenses are sometimes amplified or conceded by IMEs. You made a crucial recommendation not to even have an IME, because the claimant could go to the IME, present a story, and for what purpose would the IME say it's related or not? Like, we wouldn't be able to have an IME within the expedited hearing timeline that would have the benefit of those subpoenaed records, because we didn't know what hospital he went to until he filed the claim. So, I gave a little teaser to our audience about dragon's blood. So what is that? And how did that come into play?
So he told his hospital, in addition to, the popping his blister with a nail, that it became infected, and then he was treating it with something called dragon's blood, which I believe is like a South American sort of home remedy type of thing.
Right. It's okay. Like, you don't have to accept Western medicine, but very, very interesting to the cause, right? The idea that if you have a legitimate work accident, you are not self-treating, right? You are not doing things on your own. You're going to seek care that is the responsibility of someone else.
Right.
And so at what point do you think that this claimant decided to say it happened at work? Because it couldn't have been when the blister happened. It couldn't have been when he popped it. He is not thinking at that time that it's a work accident.
There's a tidbit in those hospital records that say he does not have insurance. So lo and behold, about a week later, it all happened very quickly, but at the same time, suddenly it's a work accident, but yet, like you say, he didn't tell anybody at work. And, he was alleging that he fell down. There was, a trail of blood coming out of his foot. Obviously, if you're going to be injured on a job site and there's a hole in your shoe and your toe has a, stab wound, you would think somebody would be reporting a trail of blood everywhere, but nobody reported anything like that.
Right. And for a nail to go through a boot, leave a trail of blood, and for nothing to happen, either it didn't happen or it's one of the greatest cover-ups that should be on TV.
Right.
What was the claimant's argument for getting it established? Like, once those hospital records are out, how come it isn't just clear that it's not our client's responsibility?
Well, the hospital records were interesting because, it's at some point he said he popped his blister with a nail. At another point he said, he stepped on a nail. And at another point he said he stepped on a nail at work. So he was telling them, multiple different versions of what happened. So they were, of course, arguing that the record shows that, it does say that he stepped on a nail at work. But yet he also then testified that he stepped on a large piece of wire at trial. So that's
Going
a whole
back
other
and
aspect.
forth.
Yeah. Keep changing his story.
Yeah. All right. Well, shoot or shoot, I guess. I guess the idea is that when you realize your toe or your foot needs to be amputated and your personal insurance doesn't cover the cost of the surgery, or you don't have the right insurance to do that, then you're going to be starting to point fingers. But luckily for our client, you were on the case. You did a deep dive and investigated into the real nature of it. I think that's like an important takeaway too. Like we've been doing this for years, and so many times claimants will file claims and their hospital records or urgent care records are never in there.
Right.
It's like, their first medical record is from the doctor that their attorney told them to go see.
Mm-hmm.
Right. And so I think that's a really big takeaway, is trying to really, and I guess this really is the time where I should say defend from day one, where you have to place yourself in the shoes of what happened at the time and try to track that timeline from there, instead of just relying on the claimant to be, acting in good faith.
Right. So it was definitely helpful to subpoena all those records, even though, it's like I said, one of them would say stepped on nail at work. We got all that other stuff saying popped his blister with a nail, tried to treat it, it stayed infected, that sort of thing. He didn't have insurance, so all these other factors coming in. So quite a lot of records to come in, but that way, like you say, otherwise it would have been sort of like the highlight reel that the claimant wanted us to see.
Yeah. Good. Yeah, that's a good phrase for it, the highlight reel, because it's like if the claimant can choose, then of course he or she's going to look the most injured. From that, you'd think that that'd be enough to cap off a year, but very soon after that, you had a case where we were litigating labor market attachment, and sometimes the job searches that they provide, I'm almost wondering, do they think like no one's going to read it? Do they think like I'm going to submit voluminous records and then this one's going to get kind of like just stuck in there, and then, it's just one out of many and they won't be read? Because, we had a case that you handled where the types of jobs that this person was applying to, you try to be as stone-faced as possible, but you just can't help but laugh sometimes.
Yes.
So
I think his job search became the firm standard for a little while of what to look for.
Right. Hey, let's look at this one, right? That's an example of what is not labor market attachment.
Yeah.
So what was this person's pre-accident job, and what were his qualifications in order to determine what types of jobs he should be looking for?
Oh, this one is actually so old that I think he was definitely a garbage collector. I think this is the one where he slipped and fell, but didn't actually fall, and had some kind of, severe injuries he was alleging to his spine.
Yeah.
So, was directed to produce labor market attachment, and, another one of these situations, like you say, where they just kind of flood the work search record with proofs, and honestly, yeah, hope that the opposing side doesn't look into all this, I imagine, because, they want to have the judge look at, there's 400 job applications here. Obviously, this person has been diligently pursuing an effort.
Right.
But yeah, when you actually take the time to look through, you can uncover a lot of questionable.
So what did this guy decide to put in his job applications?
So his resume, that was a big thing. That's why I always ask for a resume. The first thing was something like, I am disabled. I am severely disabled, basically.
Right.
And, I am trying to look for work.
It's like in big bold letters, please don't hire me.
Right. It was no reasonable employer would look at this and not throw it out.
No reasonable applicant would put that on a resume saying, I am severely disabled.
Yeah. I forget what he said exactly, but I wish I did look at that beforehand. But just going on and on about his work restrictions.
Yeah.
Certainly more about his restrictions than any kind of qualifications that he had.
Yeah. And so that already paints a picture of someone who is trying to subvert the obligations of the system that, we're in. And you think to yourself, okay, he's a garbage truck driver with a questionable accident mechanism, and now he's trying to say to prospective employers that he's severely disabled. The red flags continue to mount. What are the types of job search proofs that you ended up reviewing?
The main one that I remember is his application to Victoria's Secret, and he would include the job postings, which is appropriate, and the responsibilities or the requirements was that you would be able to help the customers find the perfect bra fit.
And
so that got an interesting reaction from the judge, certainly.
Right.
On cross-exam.
The idea also too, right? How do you formulate a cross-examination question that you can ask with a straight face?
I think you watch comedy specials and skits and see how the straight man plays it, and it works out perfectly. I still remember the judge's reaction and then my reaction back, trying to not laugh because you are on camera, but you're clearly seeing the judge have a visceral reaction to these ludicrous job postings. That was the main one that I think struck.
It's like, so you to be a, I guess like a fit specialist or whatever it was called at Victoria's Secret, you would have to have experience, and maybe it's because I'm more jaded than you, Brad, but I guess I don't know if I'd be able to help myself in asking the claimant if he's ever tried on a bra himself.
I didn't go that far.
You probably don't need to. I think I'm just, maybe a little extra at this point, but needless to say, right. That probably wasn't the only job. Right. It wasn't the needle in the haystack. And I guess, we could probably do a full podcast on all of his job search applications, but, I think the result is obvious, but just so that our listeners are clear, like, what did the judge decide in that case?
Essentially, between the resume and between all of these jobs that he wasn't qualified for, or, just were, improperly, just totally unrealistic, the combination of these things showed that it was not actually a good faith effort. So I think, we made the argument that he was basically poisoning these job applications. As ridiculous as some of these jobs were, he was also just poisoning every single job application with this bad faith resume.
I love that phrase, poisoning job applications. That's great. Mm-hmm. That's such this visceral feel to like a summation argument where you're a storyteller almost.
Right.
And you're saying that, this person is really just making a mockery of this system. And, to your point, I could see very many firms and attorneys or even judges, and not because it's unreasonable, just because, we work in a volume industry, just saying like, oh, you applied to 200 jobs over the course of 2 weeks or however long it was. That is pretty persistent, right? Like, we usually like to say that, if one was out of a job, how often would one look for a job, right? Mm-hmm. And 200 in a span of a couple of weeks is a lot. But it's about the diligence that really was the key to your win. It seems that if you could point to the fact that he's, saying to employers, I really don't want this job. Please don't give me an interview or an offer that I am going to be presumed to have to accept. I'd much rather keep collecting workers' compensation benefits.
Exactly.
From my employer.
And that was another argument, that he had applied to hundreds of jobs and had never had an interview.
Never. Right,
so that just goes to show.
I'm trying, Judge. I'm trying. I just never got an interview. Otherwise, I would gladly take a job. Mm-hmm. So that's another good one on the books. And then, more recently, the wins that you've had are still very interesting. We had one a few months ago that dealt with, an alleged injury to the face. Mm-hmm. And that's always something that, it's not something that you can fake, right? Or maybe it is.
Well, it was an interesting one. Yeah.
Involving scarring and certain things like that. So what do we have to tell our listeners about how that claim started, right? So let's kind of build it up. Like what happened? What did the claimant allege happen? And how did we get to where we are?
The claimant worked at a metal production plant and was alleging that he was using a buzzsaw and the saw malfunctioned and pieces of the saw sprang up and lodged in his face.
That makes sense. I mean, without anything further, seems like an occupation with a hazard that could potentially be a problem. How did our client feel about that?
They denied it from the get-go, and I was interested. I actually pushed for settlement, but they were not particularly interested in settling. They wanted to push for disallowance. They felt like this was illegitimate, and also it was filed significantly untimely.
Oh, okay.
If I recall correctly.
Yeah, and I think that's a good talking point, because I think it's valuable to try to pursue all avenues of closure. And your immediate thought was, maybe, and I think you know the case better than me for obvious reasons. The idea that you wanted to push settlement is kind of interesting because it still gives our client a reason to consider their options.
Yeah.
And they said that it wasn't legitimate. And what was the reason, or why would that not be legitimate, or was it just because it was an untimely notice?
I think there was a lot of confusion because he had told them he was injured by wiping his face with a glove, a work glove that had pieces of metal in it. Mm-hmm. So he had changed the mechanism and changed the date. So there was a question of when did this injury happen and how did it happen? So I think it may have been more of a question of was this filed untimely or not.
Right.
But there was just a lot of ambiguity.
And I think what's interesting too is you produced multiple witnesses.
Oh my goodness.
Right.
Actually, he ended up producing the witnesses. But I remember I tried to get a supervisor who was no longer there and didn't think she was going to appear. And then lo and behold, he had her appear as his witness.
Wow.
So I was, coming up with questions for her on the spot.
So you were almost thinking like, I'm going to present her as like a direct examination witness,
Right.
tell her a story. And now he is producing her to tell his story. Mm-hmm. And you had to pivot in real time to like cross-examining her.
Yeah. So he had her testify that, yes, she told him, or he told her
right.
that this happened. It happened from the metal saw. She was, in my opinion, credible. And, the one thing that nobody could pin down, though, was when did this happen? So he had a second witness who also said, I saw it happen.
Wow.
But he couldn't say when.
That's a tough break. Break. It's certainly rare that a claimant brings in their own witness, because usually the deck is stacked against us. And for the claimant to bring in multiple witnesses and get to the point of still not having a claim established means that it almost, I don't know, actually, do you think that the witness production by the claimant actually hurt him?
I don't think that was what hurt him. I think he testified on cross that he had a prior injury. He had gotten dental surgery and some kind of medication, I guess, afterward caused this reaction on his face. So he testified that he already had this facial scarring, basically, from before this whole thing with the alleged metal getting stuck in there.
Right. And a lot of this then turned on, if these witnesses could be deemed credible for the claimant, then a lot of this is then going to determine by your expert witness development through deposition testimony.
So that was our kill shot in the end. And I'll give a shout out to Andrew Berman for doing that deposition where the doctor would not concede causal relationship and said something to the effect of, well, I wasn't there. So how can I tell you? It was very strange. I don't know exactly how he got that, but the doctor had performed surgery, but some of the records would say that metal was removed from his face and some wouldn't. So again, a lot of unclear what happened to this person and what was even taken out of his face in the end. But the doctor could not conclude causal relationship, and I think that was ultimately what the judge relied on.
I won't say the judge's name,
Mm-hmm.
but that is a very typically tough judge to win.
Yes,
Controverted cases before.
for sure.
And so the idea and the lengths that you had to go through to really achieve this type of result, it not only reinforces the investigation into all of these things and, the use of deposition testimony as a real means, right? Again, right, for a situation where if we don't know when this accident occurred, why subject our IME to this process? Let's go forward with cross-examination. I think is a very important takeaway. Another thing could be too, right? Like the communication that you're having with the client at the outset of the claim, where you're talking about settlement, they're talking about pushing forward with the disallowance, and the professionalism that you're showing by saying like, look, I think this case is settleable because, we have a lot of moving parts here. But for them to pick an option that wasn't your recommendation, but you still move forward anyway, is a credit to you and your paralegal. So I think that's something to be very proud of. It's almost like, we don't have a system and values like that. But another great win on the books for you, Brad, which leads us to our last case to talk about. It's our most recent one a few months ago, where, I think this was, when I read it on the website, this was just like, I could talk maybe for an hour on this case alone, just based on the salaciousness of the details. It involves, a little bit of a gamesmanship by the claimant. So let's give our listeners a backstory there and how it played out.
So this guy was a supervisor, and he was in an accident at I think it was like a furniture type of store. And basically he was hit by some kind of forklift. So no contesting what happened to him, pretty significant injury. And we conceded all the accident itself. But apparently after the accident, he was still coming in part-time here and there as best as he could, and operated a forklift one night when doing the stalking, and drove the forklift somehow into the wall, put a big hole in the wall, and then put a table in front of the big hole and left the job. And then when he came back the next day and was questioned about it, he was apparently very hostile to the staff and walked off and never came back.
And did he, we know that he's alleging an injury from doing this. Did he say that it was him driving it into the wall that caused the injury?
It was two separate incidences. So first he was injured on the forklift somebody else was driving, and then this thing was him just driving the forklift on his own into a wall somehow. But his argument, he never contested the driving the forklift into the wall. He was trying to say that it happened before his injury, and we were saying that it happened afterward.
Because if the incident of driving the forklift into the wall happened afterward, then the reason that he is no longer working was not due to some injury.
Right. Unrelated. Totally unrelated to his work injury condition.
So he's hostile with the staff. He's, which is always a good sign that you have a legitimate case when you start getting angry. It's a claim where I guess again, to really support the notion that we are defending the integrity of employment, right? We actually accept compensability for the previous injury,
Yes.
right? So we're saying, yes, we will pay for the treatment you need for this particular body part and diagnosis, but we're not going to pay you for your inability to work because you very clearly are trying to manufacture some type of, issue with the forklift, and that being the reason.
Mm-hmm.
And so one of the things I loved about this particular case was the excuse he brought about he couldn't bring back his key. He couldn't bring back the keys or something.
Yes, he couldn't bring back the keys to the job ever because of his accident. Meanwhile, his accident was, I think, not anything that would impair you from actually being able to walk around.
Right.
So that was, I think, a benefit to us. And I certainly put that in my summation. He couldn't even bring back the keys. I basically showed what an incredible, testimony he was providing. And he was one of these claimants that immediately started on cross talking about what a huge benefit he was to the company. And whenever somebody speaks like this to the judge, just let them go as long as they want.
Right.
Because they just look ridiculous.
Yeah.
And, he was changing up his story. Nothing seemed to line up. And we, in that case, wanted to really back up our position of when the accident happened. It was a little bit hard for us to show exactly what day it was, but we did have the records to show the days that he was coming in or had been scheduled to work after the accident and didn't show up. He was saying, I think maybe he came back like once, but our records showed that he had clocked in multiple times after that. So we definitely want a paper trail because it was a little unclear. Unfortunately, they, of course, didn't have the surveillance anymore of him crashing into the wall, which I don't understand, but it seems to be a common issue with trying to save the juicy surveillance.
It's good that it wasn't needed if he conceded to it happening.
Sure.
Right?
Yeah.
He's saying that he's driving the forklift into the wall and that, the keys are just this cumbersome object that I can't bear to lift them and bring them back to you that you can use the forklift as part of your process. Yet you are such a benefit to the company, such a valued member of this employer.
Mm-hmm.
And that also is an important point you just brought up, right? Like the production of documents that kind of explain not only the timeline of events, but are specifically used to discredit particular bits of the claimant's testimony. Because once you do that, you're kind of opening up this can of worms to say, it's like, well, here's proof that you just lied. Right. So what else are you lying about? I think that's one of the very, very important aspects of what we do, right? Like the investigation into those records help you support really what can be a common sense approach. The common sense approach is you were terminated because you drove a forklift into a wall, tried to cover it up, and terrorized staff when questioned about it. And because of that, you're not working. And now when you're going to bring up this old injury, we're actually going to pay for that injury, but just not you, because that's not the reason you're out of work.
Right. And he was actually found 100% disabled, I think, like the day after he got the termination letter.
Oh, of course he was, right? Because why would he have any ability to work? Maybe they were saying, it was actually causing his ability to drive the forklift into the wall, like he's so impaired.
Yeah.
But of course, those steps happen in place to try and make a bad case a little bit better. But I think the work that you're doing to investigate, again, really shines through. So it's been a good run for you, Brad. It does kind of put a little bit of the pressure on to keep such a good streak up.
Well, I have another win for the records, hopefully coming in soon.
Oh, a little teaser. Okay. All right. I mean, usually that's my job, but we might have to look at that down the road as well. If you keep that close to the vest. Like I said, it's been a good run. I think that again, I think there are certain takeaways that you can use to really move forward with other cases and things that our clients and listeners and prospects can certainly learn from. It's the deep dive, right? Going into those cases and finding that buried treasure, that little nugget, the needle within the haystack that really turns a case, right?
Yeah.
Because we almost receive these cases with the deck stacked against us. I don't want to say almost, we do. And so the work that we put in to try and reverse that trend is certainly very admirable. So congratulations.
Thank you. Appreciate it.
So for Bradley Haymes, my name is Christian C.U.B.A, reminding you to defend from day one. Have a good summer, everybody.